And I couldn't think of any better way to get us started than our first discussion between Roger Cox and Philippe Sands, two of the most interesting legal practitioners working on the interface between multinational investment and global environmental policy. Each with a unique set of insights and experiences from domestic and international litigation. And we're extremely grateful also that the climate editor of the Financial Times, Emiliya Mychasuk, has agreed to moderate. So I'll now hand over to the virtual floor to you, Emiliya, to introduce our speakers and kickstart the discussion.
Thank you, Lago. Thank you for this discussion with a couple of the most foremost minds about international laws and their relationship to climate change. We're privileged to have Philippe Sands, human rights barrister, professional author, who recently co-chaired a panel that produced the legal definition of the crime of ecocide. And also Roger Cox, as you say, the litigator successful on behalf of the Dutch case against Shell to impose a mandate on the company to cut carbon emissions by 45% by 2030 in line with human rights obligations. He's now involved in targeting banks and other boards. Gentlemen, thank you for being here. We have the headlines today that the World Meteorological Organization has concluded that we're on course to breach the Paris Agreement target of 1.5 degrees of global warming within 5 years. It's an update on its previous guidance, and it's backed up by the UN climate scientists body, the IPCC, as we've heard, which has been warning about this danger for some time. And yet it's more than 5 years since the Urgenda climate case against the Dutch government was first brought, the first in the world, in which citizens established that their government has a legal duty to prevent dangerous climate change. Against that, we have the actions under the Energy Charter Treaty we've heard about against governments by investors over their attempts to stop coal, oil and gas projects. Can I ask each of you to put this very slow-moving legal process and the use of arbitration in the context of that limited time frame that exists to combat climate change? Philippe, could I come to you first?
Sure. Well, thank you. Thank you very much, Emiliya, and thank you to the organisers. And lovely to meet you, Roger. We've not, I think, been in touch before. I'm
likewise.
Very much looking forward to hearing what you've got to say about Urgenda. But just to put it in context, I am speaking obviously in a personal capacity. I focus on the public international law aspects. One thing you didn't mention, Emiliya, and I want to be very careful about this, is I sit as an arbitrator in investor-state arbitration cases. And so I obviously want to avoid reference to any cases that are pending or in which I'm involved. And in that context, I'm going to be a little careful. What I would want to say is this. Having been involved from 1989 in the climate change negotiations and a participant in the 1992 UN Framework Convention on Climate Change, I've followed these issues from the get-go, and they have been, if you like, fully infused into my being. I'm fully aware of the legal issues, the legal developments, issues of interpretation, issues of application. But I'm probably in a very small community for my generation in that sense of being pretty much on top of the legal developments on international environmental law generally, but in particular on climate change. So in a sense, my two worlds have collided. My first academic work was on state contracts, concession agreements, investor-state arbitration. And these two issues have now begun to come together. Typically, the issue that would arise in investor-state arbitration is that a claim would be brought by an investor making an argument that steps taken by a state, which is the respondent state in a case, in some way have interfered with property rights under a bilateral investment treaty or under the Energy Charter Treaty or under a contract or under some other international instrument. And the respondent state may argue that it has taken the steps that it has for any number of reasons, which could include, given the subject of the conference that we're talking about today, measures taken to protect the environment. For example, hypothetically, there may be an effort to limit the use of oil, gas, or coal in new authorizations or on an existing authorization in which the need to comply with a climate change obligation means that a project that has already been decided may be revisited and limited, or it may be in relation to the kinds of cases that have arisen under the Energy Charter Treaty, where an investor has invested in renewables at a very early stage of these types of projects, and that as climate change rules have developed, there's been an increased incentive for corporations to develop new technologies, which has caused the prices to go down for renewables, solar, photovoltaic, and other things, which then causes a respondent state to reduce, if you like, the rate of return, which is then subject to legal proceedings under the Energy Charter Treaty or a bilateral investment treaty. The simple point is, where the rubber hits the road is a state may sometimes justify the actions that it has taken by reference to the need to meet new environmental obligations that did not exist at the time when the investment was made or when it was foreseen. Now, I'm involved in a number of cases that raise those issues, and to cut straight to the chase, it seems very clear to me that the existing system of investor-state arbitration is simply not able to take into account changes in consciousness, changes in environmental consciousness, changes in climate change consciousness, changes in terms of what society has determined is or is not needed for the public good going forward. And there are two aspects of investor-state arbitrations that concern me particularly. One aspect is in relation to the applicable law provisions. When you get an investor-state treaty arbitration taking place, the arbitrators are obliged to apply the applicable law as determined either by the Exit Convention or the Energy Charter Treaty or the Bilateral Investment Treaty. And as interpreted and applied, these treaties tend to skew the arbitrators away from having full regard to these emerging or new obligations, including in relation to the protection of the global environment. So there is an issue on the applicable law. I happen to think that it's not an insurmountable issue, and I've given a number of awards recently where I've addressed that issue. One recent one is the case of Eco Oro and Colombia. It's not a climate change issue, but it raises similar issues where a new environmental obligation has come into play after the investment was originally conceived or implemented. So applicable law is an absolutely core issue. Second issue, which I think is much more difficult to address, is the whole system of private arbitration. Basically a system in which individual lawyers are brought in to act as arbitrators. And there are two fundamental issues that arise. Firstly, the coterie of individuals who act as arbitrators in these cases are generally, not always, there are some exceptions, from a generation for whom climate change is not a living, breathing, real issue. In their legal training, they didn't address environmental matters. And so these arguments about the environment, about climate change, as concerned with commercial interests, obligations in relation to the rights of investors or property, tend to get limited. And secondly, the investor-state arbitration mechanism is skewed towards an appointment system which encourages people to move towards arbitral awards, which will increase rather than diminish the prospects of being reappointed. This is particularly the case for the president of a tribunal. And very frankly, giving effect to climate change obligations in the context of the interpretation and application of a provision on fair and equitable treatment or expropriation or discrimination or so on and so forth, it is a big ask for someone who comes with that baggage. So I'm raising a couple of fundamental questions. The substantive law that's being applied, climate change law, is not fully integrated into investor protection laws. And secondly, the nature of the system, which is skewed against tribunals really giving full effect to these new environmental obligations and commitments, which are recent in generational terms, and that's particularly the case on climate change. So I have very serious concerns about whether the system is capable of dealing with what the science and recent legal developments require.
Thank you, Philippe. Roger, can I hand that to you? Do we simply just not have enough time to deal with all of these complexities of the application of the law and in particular the use of arbitration, the context, that process, that time-consuming process, and the training of arbitrators and so on? Is the clock ticking?
The clock is obviously ticking, and everybody knows this. In the considerations of the Glasgow decision last year, it has been clearly stated that this is the critical decade, that we need to almost halve our worldwide emissions by 2030. And given the fact that we have 8 to 9 years left, this obviously means the clock is ticking very hard. We're moving not nearly fast enough. That's one thing that's for sure. We've already known since the Copenhagen COP in 2009 that this is a very material issue and that it's a very urgent matter. We also have known since 2009, when the UN Human Rights Council already declared that there is a link between climate change and human rights, that this could become a human rights issue. And I think that that is also the aspect that might lift us up a little bit and gives us some hope, because now, since the last 6-7 years, since the first Urgenda case, where it was established that climate change indeed is a human rights issue and affects the human rights in the Netherlands, so let alone in other countries in the world that are less capable of adapting to climate change. You could argue, since now highest courts in the Netherlands, in Germany, also the court in Belgium and Ireland and some other countries have declared that climate change does indeed, dangerous climate change, that is, meaning using the definition of the UNFCCC and the Paris Agreement combined with one another, basically the 1.5 degree target. So breaching that 1.5 degree target basically means we're violating the human rights across the globe, the right to life, the right to well-being, and so on. And from the fact that it is a human rights issue, that derives obligations from that for states, but also for companies. And I think that states, as parties to these investment treaties, do not only have a material human rights obligation to proportionally mitigate their CO2 emissions and other greenhouse gas emissions as an obligation under human rights treaties. They also have to adapt, of course. But on the other hand, they also have to use all diplomatic, economic, legal avenues that are to their disposal to make sure that they will create effective remedies to this imminent human rights violation. Meaning that if we would conclude that investment treaties are a roadblock to become effective in protecting human rights, then I think it's a human rights obligation for all nations to make sure that they break down this roadblock and make sure that that these treaties will become Paris aligned, or put in their significant best effort to make sure that they will become Paris aligned as quickly as possible, and use every avenue to make that happen. Also, states obviously have an obligation to cooperate with one another to make sure that human rights across the globe are protected. And this follows already from the UN Charter Treaty of 1945 and the Universal Declaration of Human Rights and other human rights treaties. So we have a good faith obligation as nations to one another to help each other out, if you will, in this respect. And I think that we as a legal community have to actually make clear to states that because of this human rights issue and because of these human rights treaties, it's not it's basically a hard obligation for them to make sure that they will take effective remedies and do anything within their power to create the tools that are necessary to achieve this emission reduction goal for 2030. And I hope that giving this legal pressure, we might maybe accelerate some of our actions in achieving the Paris goals.
Thank you, Roger. And so, Philippe, do you think that we can accelerate? Can arbitration be accelerated? Can there be an integration, a further integration of climate policy into the investment treaty?
It can. I mean, the system, I think, is not inherently skewed against delivering climate goals, but as currently structured, it is part of the problem, not part of the solution. And I've explained two of the central reasons why. I mean, I'm speaking here from personal experience as an arbitrator. I mean, imagine what it means to sit as an arbitrator with a colleague who has not come across, for example, the Vienna Convention on the Law of Treaties, and therefore is not aware, when interpreting and applying either a bilateral investment treaty or the Energy Charter Treaty or some other treaty, that when the applicable law provision says you must apply other applicable rules of international law in relations between the parties, you are entitled to reach out and take an obligation, such as an obligation that relates to targets and timetables for emissions of CO2 and other greenhouse gases, and apply those in relation to the Act. So there is a resistance to doing that. And the resistance to doing that is part of a structural problem. So the question is, if you want to address that, there are a number of options that are available. One of them is to adopt a series of not even guiding principles, it has to be obligations to ensure that arbitrators, decision makers, adjudicators have proper regard to what it actually means to implement into the interpretation application of an arbitral award an obligation that exists in relation to climate change. And secondly, you've got to completely restructure the system of arbitral appointments and ensure that the pool of arbitrators, if you want to go with that route of privately appointed arbitrators dealing with these issues, is a community that is really comfortable with these new areas of the law. Now, exactly the same thing has happened in domestic law. Roger is much more knowledgeable than I am on the domestic context and obviously in the Dutch context, but the law and adjudication always follows. It's not that it's inherently incapable of doing it, it's that a series of obligations are taken on board, and it takes time for the community of adjudicators, whether they are domestic national judges or international arbitrators, to really come to grips with what is going on. And taking your question, we don't have time on our side. These are issues that are arising today. So the question is a structural one. How do we educate our judges and arbitrators? And how do we develop an approach to dealing with the applicable law, which is much more holistic and which takes into account obligations arising out of the narrow field of investor-state arbitration? Take a look at the community of international arbitrators. There are many terrific individuals, but the vast majority of them have no background, no understanding, no feel for this kind of issue. And there is no effort to train them, nor is there any effort to work with them to begin to understand that these obligations arising outside of the field of investor-state arbitration, a bilateral investment treaty, the Energy Charter Treaty, need to be taken into account and applied in interpreting and applying, say, the Energy Charter Treaty or a bilateral investment treaty. So I don't want to be totally pessimistic about it. It's not that it's impossible to do, but there is a hell of an effort ahead of us to change the mindset. And the mindset for most arbitrators is essentially a liberal mindset, which is intended to ensure the protection of the rights of investors in one form or another, and a mechanism of investor-state arbitration, which causes a lot of arbitrators to want to sort of cut the cake in half, give a bit to one side, give a bit to the other side, and that militates against the kinds of tough decisions that need to be taken. I've recently written an award in which I have described the Energy Charter Treaty as a carbuncle. It was negotiated in the late 1980s in a totally different global context, and it needs to be radically revised on applicable law principles and on the appointment of arbitrator principles to ensure, if the issues that you're raising are to be properly addressed, that they can be addressed in a way that you turn around the system to deliver the kinds of results that the Urgenda result. I mean, I commend Roger for his work, because what that single award, that single judgment of a Dutch court did was to set a benchmark which other national courts are now beginning to follow. And as national courts go, international courts and tribunals will surely follow, but it's like a vast sort of oil tanker, and causing it to change direction is going to take a long time, and we don't have that time.
Can I ask you very briefly, you refer to the resistance of your legal colleagues as an arbitrator, without divulging too much. Can you say whether that is more on the investor side or on the state side, or is it equally distributed resistance?
You know, that's a very big question, Emiliya. Part of the problem with investor-state arbitration is that there are a set of revolving doors. Firstly, you have an inherent conflict built into the system in which it is possible for the same individual to act as counsel in one case and arbitrator in another case. So it's not impossible to find yourself, as I have done, sitting with a fabulous individual, but who he or she is spending the morning working as counsel for an investor in one case, interpreting and applying what fair and equitable treatment might mean, or what expropriation might mean, including in the environmental or climate change context, and then spend the afternoon drafting an arbitral award. So there is an inherent conflict, and the idea that somehow that individual can keep their work as counsel out of their mind in acting as arbitrator, in my view, is plainly a nonsense. But there's a second revolving door, and it comes to your question. Look at the number of individuals who have been in government, okay, working on these kinds of cases, including on the environmental side, who then get picked up by the law firms, largely the large law firms, and taken out of government and whisked into very fancy offices in London or Geneva or Washington or New York or some such place, and increasing income, you know, by tenfold in the space of a month to act as counsel in investor-state cases. So the system is skewed against individuals in the governmental departments from going out too far on a limb in making the kinds of arguments that perhaps some may think ought to be made. And on the other side, looking over their shoulder very often and asking themselves the questions, well, if I go too far as arbitrator, I may put myself out of work in my work as counsel. So I think the problem may exist on both sides. And within government, the problem that you have very often, not always in my experience, but very often, is the sort of ring fencing of internal governmental departments. So there will be a unit, it could be in the Ministry of Foreign Affairs or in the Ministry of Justice, that is dealing with investor-state arbitration on behalf of a respondent state. And the folks who are dealing with climate change issues are parked in a different ministry, environment, or some other aspect. And the communications between different government departments, different ministries, as we know from hard experience, often is very poor. There's competition, there's challenges, there's, you know, egos that are out of control. And so there is not, as I often see, a seamlessness in governmental decision making. And I think on the government side, knowledge and experience of climate change issues has very often not seeped into the hands of those who are charged with arguing for the respondent state, the defense of cases which could address climate change issues. So I think the problem exists on both sides. I want to be very careful here. This is not a problem that I'm attributing to the character or qualities of particular individuals. These are structural problems in the system. They can be addressed, but frankly, no one really wants to address them because everyone's got a vested interest in maintaining the status quo, and the status quo militates against the type of significant agenda type cases at the international level. I think they will come, but they will take time to come.
Well, it's a fascinating insight into the process. Roger, can investors any longer, just taking a step back, and as someone who's vested in shaking up the status quo that Philippe describes, can investors and their representatives, whether it's arbitrators or through the revolving door council on the other side, can they any longer claim not to know the risks involved in projects due to climate change?
From a national law perspective, I would say it's totally impossible to claim that you're not aware about climate change, its destructive consequences, and what needs to be done to solve it. I would even argue, as I've been arguing, that at the latest by 2007, with the coming out of the IPCC AR4 report, all material evidence was there for everybody who should be in the know, meaning states and large CO2 emitting companies, that something had to be done, that there's a limited carbon budget, which means that we have to be very careful about what we will still emit, et cetera, et cetera. So being now in 2022, in my opinion, there's no way one can argue that you're not aware of regulation coming about in relation to, especially in relation to new investments. But I would also say that over the last couple of years, if I would be counsel, I would argue that the proof is out there that all large CO2 emitting companies, especially the public listed ones, you can read their annual accounts, and they have this, as they call it, strategic risk appetite, meaning that they are fully aware for years already that their business case could be materially affected once there would be an acceleration of climate regulation and or successful climate litigation and other legally related issues. But they're also willing to accept this strategic risk appetite. And so their shareholders are also willing to accept that risk appetite and what comes with it. Because on the one hand, you have these huge revenues coming your way, which makes it still relevant to accept that particular risk appetite. But once the investments become stranded, it makes no sense at all that if people and companies are willing to actually with full knowledge are willing to invest in new fossil fuel infrastructure, that you would still be protected by an investment treaty. Because I think it's not just about fair and equitable treatment, it's also about legitimate expectations. And I think that looking back in time, I think I could argue on the basis of the evidence that we know, probably since 2015, you will see a lot of annual accounts that are very much aware, that declare that the business, the company is very much aware about the material risk for the company if they would be regulated. So there has to be struck a balance there, I think, in these cases. There's obviously also still governments who've been proactive in luring these corporations into new investment. That will also happen. So you have to strike a balance there. But I think that most of these investors, well, at least part of the stranded assets, I would argue would be for their own account, since they fully and willingly made those investments, knowing what material risk would be involved. And so you cannot just privatize the revenues on the one hand, and then once you end up with some stranded assets that you could have known of, and then let states and therefore the public pay the bill. So I think there's also a lot that can be done on the council side to make sure that arbitrators rule differently on these cases. And I think that there's a lot of proof out there that could make this type of argumentation.
Emiliya, can I just come in on this? Because I think
Please.
Roger has really raised a point that is absolutely where the rubber hits the road on this. And I'm going to give a hard example. This is the issue of legitimate expectation and a very crucial aspect for me as a lawyer, whether the investor has done a due diligence in terms of what is coming. There are, as you know, I mean, a series of cases governing renewables involving a number of countries around the world. Investments first thought about in the early 2000s, in which governments offered very nice rates of return for companies that were willing to invest in solar and photovoltaic and wind and various other things. And then as the imperative to protect the climate system increased, the price, the cost of the technologies went down. And governments found themselves, including in the face of the 2008 financial crisis, in a very delicate situation. The basis upon which investments were made in the early 2000s was premised on a rate of return and cost of technology and cost of capital, which had dropped very significantly. And so when governments turned around and said, look, this is ridiculous that you're getting this rate of return, which is was intended to encourage you to invest in the context of a scheme that's designed essentially to protect the climate system, we're going to reduce the rate of return. And there's been a whole series of cases on the question, what is the legitimate expectation of the investor? And what has happened in those cases, and I have expressed clear views in certain awards on this, is that arbitrators have effectively dispensed with the need for due diligence. And this is extremely problematic. It is the case now that I do more due diligence if I want to buy a flat in London than in, you know, for 300,000 or 400,000 or whatever, if you can buy such a thing, than an investor putting 50 or 60 million into a renewables project is required to do by arbitrators. How has that happened? That you can effectively now get away with no due diligence at all in relation to making a claim. And that is the reality of many of the awards that have come down. The investors, the evidence is there has been no due diligence in relation to whether a rate of return or a regulatory framework will be maintained in the face of regulatory change, for example, to protect the environment, for example, to protect the climate system. Roger said, change the position of the council. I wish it was so easy. The problem is not with the council. The problem is with the arbitrators, because there is a mindset in the system that is skewed essentially to protecting the reasonable investor. And what the reasonable investor means in the investor-state arbitration context will be a very different thing from what I think a person on the ground considers to be the reasonable expectation of an investor. That is precisely where the problem exists. It is plain as night follows day that rates of return are going to change, that if you invest in oil and gas and coal, you cannot reasonably expect the regulatory framework to not suffer very significant change going forward. How are the arbitrators to deal with this? The record thus far is, I think, very problematic.
Roger, in the couple of minutes that we have left, is it just simply too important to a factor to leave to the arbitrators to decide? And could you see, can you sort of give us a very brief vision of what sort of framework beyond the investment treaty you think would be effective?
Oh, that's a very complex and difficult question to answer. I would just say for where we stand now in this discussion, I would argue that take a step back, see that climate change is not an environmental issue alone, it's a human rights issue. Make sure that we all get the right view on what that means for the obligations of states, but also what that means for the obligation of large CO2 emitting companies, which basically are more powerful from a political and financial and economic stance than almost all countries in the world. So looking particularly, for instance, to Shell, there's only 4 countries that emit more than Shell does, which are India, China, the United States, and Russia. So looking at these big CO2 emitting companies and looking at the fact that we're talking about human rights issues here, they also have an obligation to proactively move and become Paris-aligned as quickly as possible, or risk violating the duty of care in relation to the damage that they will create and the human rights violations that they will create by proportionally contributing to climate change. And they have a legal obligation, in my opinion, where we have a moral obligation. We cannot be held accountable in court for our contribution to worldwide emissions, because our contributions as a person are too small. But for instance, Shell is between 2 and 3% of all emissions are related to Shell activities and Shell products. The same goes for other large oil and gas majors. The same also goes for the large investors and financial institutions that facilitate these companies. And I think that once we really start to understand that they cannot just wait and see what happens and wait to be regulated, but they do have a proactive individual legal responsibility to start acting and becoming Paris-aligned and make sure that their investments become Paris-aligned, then we could hopefully move a lot quicker as a society than we're currently doing. And that brings us back to the beginning. Since time is running out, and this is the critical decade, all relevant decisions have to be made within the next 1 or 2 years, which gives us like 6 years to implement our decisions and make them count. So it's an urgent matter in the most urgent sense of the word. There is no room for delay. And we will and we see this as our moral duty as a legal community, at least the legal community that I'm part of, is to make sure that we try to hold these large systemic public and private institutions and parties and countries to account for their responsibility in creating this problem, and also their responsibility to solve this problem. And so that's basically what our framework and mindset is at this particular time, is to make sure that we apply as much pressure on anybody that has a real say in whether or not we're going to make that Paris goal, and make sure that those parties change as urgently as possible.
And Philippe, finally, do we need the threat of legal catastrophe really to affect change? You know, taking a step back, as Roger says, even with people like you involved. You've been involved also with other similar, you know, tobacco and other similar life and death situations.
Yeah, I mean, it raises a really interesting question of what our individual social function is, you know, in terms of contributing to a system that we hope will be able to deliver. None of us wants to be part of a system that is part of the problem. We want to be part of a system which delivers the rule of law, which respects a treaty in its interpretation and application. And I have asked myself the question of whether the investor-state arbitration treaty system is one that I want to be involved in. I think we're getting close to a situation where reasonable people will say, this is so much part of the problem that I have doubts about whether I should continue to be involved in it. Whether that's a legal catastrophe is another matter. But equally, I tend to be a cup half full sort of person. And I suspect that 1 or 2 cases will come along which will cause the boat to change direction. There is a new generation of remarkable young people coming into the system of dispute settlement who have been educated and at their law schools and other places learned about environmental issues and climate change issues, have integrated it into their view of the law and the rule of law. And I think as that feeds its way in more and more, the system will change. So I remain, notwithstanding everything I've said, hopeful that an agenda type case will come down at some point and say, this is the direction to take. Then again, you face another problem with investor-state arbitration, and that is this. You have a multitude and a multiplication of cases. Every arbitration is self-contained. The system as such is not coherent. You can have one decision go in one direction and the next day another decision go in completely the opposite direction. And there's no organizing mechanism to keep the whole thing together. There isn't an appellate body. There isn't an overarching court which somehow brings rationality to the whole thing. And so it becomes dependent on the directions of individual arbitrators. So I'm going to try to retain my optimism that decent decisions are in sight, but I'm pretty anxious about where we are right now. And that next generation, including council, including arbitrators, including members of the secretariats, need to really integrate and ingest the realities of what the scientists are telling us is happening with climate change, and make darn sure that bilateral investment treaties and the Energy Charter Treaty and multitude of other treaty instruments are interpreted in a way that gives effect to other applicable rules of international law. So I want to try to end on an optimistic note, but it's not so easy.
Well, hopefully this will find the two of you experienced practitioners in the same room at one stage to work towards some kind of resolution, perhaps with some of these new faces and new thinking that you speak of, because it seems to me that this experience that you bring is extremely valuable. And so if nothing else, the Energy Charter Treaty has put it in a position to have some sort of holistic, all of the canons approach to solving the problem. We've gone over time, but it's been fascinating, and so I hand the floor back over to you.
Thank you so much, Emiliya, and thanks to Philippe and Roger. That was indeed fascinating, and I'm sure many of you have questions for the speakers, but they had to head off for proceedings, so we'll hopefully get a chance to hear from them again in our future work on this topic.